It feels different. Es que es distinto. No importa si estás en Saturno o en la Tierra, al final se necesita una buena charla con un amigo, especialmente if he happens to be an expert. Quien la apueste, at the end, it's all you can get.
All right, welcome back to season 3 of All You Can Debt. We're really excited to talk to today Jesse Miller, the founder and attorney at Structured Execution. From our side at Vaas, we have me, I'm Tom, leading our US operations. We have Valentina, our founder and CEO, and we have Juan Pablo, our head of legal. Right now at Vaas, we're moving into the US. And as we're kind of thinking about the US, one of the most interesting things to us is how different the legal regulatory landscape is for structured credit. I'm so really excited to get into it with you, Jesse.
Thanks, Tom. It's great to be here. So I'm an attorney and advisor to structured finance market participants here in the US. My main focus is asset-backed finance, and I've advised market participants across a variety of ABS asset classes, BS, as well as other deal structures. Really grateful that you're having me on today. Always fun to talk about the asset-backed and structured market. Really interested in what you said, Tom, bringing your products and expertise developed in various jurisdictions to the US. Always good to get different perspectives, ground up kind of viewpoints on market, especially markets that develop and are reactive to issues, historical, et cetera. So really looking forward to our conversation today.
Jesse, I have a question. You know, a lot of people, how they ask, I don't know if you have kids but how do you explain like structured credit to people that don't know anything about finance?
That's a good question. I have 4
Okay,
kids, and my
how would you explain that to your youngest kid?
That's a good one. My 6-year-old. That's a good question. Okay. So David is his name. He can have this pencil I'm holding, but he needs
Okay.
to give me back a pencil and an eraser over the course of the next month. So he says, great. Now, this is something my kids, and if you're parents, you'll appreciate. My other 3 kids raise their hand and say, Dad, what about me? That's not fair. Why can't I get the pencil? And I'll say, I only have 1 pencil. So what I do is I pull in the mom and I say to my wife, I need a few more pencils for my other kids. So she says, okay, but what I need is for you to tell David that the pencil and the eraser kicker goes to me, my wife. And in consideration of that, or in return for that, I'll give you some more pencils.
Like that. There you go.
That's great. And in our last conversation, you said something kind of interesting. Your take that documents don't necessarily create discipline in finance, and people do. And you said that you think the industry kind of overestimates how much risk is actually mitigated by documentation and legal structure. So I'd love to hear kind of unpack that, especially right now where we're seeing in the US in structured finance, in private markets in general, seen fraud, have seen instances of, maybe the legal documentation not mitigating all risk. So I think it's kind of topical now. Would love to hear you kind of unpack that take.
Sure. Yeah. I mean, structured finance deals are extraordinarily complex in that there's a lot of parties involved to make the deals tick. The existence of the deals rely on kind of a living, breathing infrastructure, real assets that are, need to be serviced. The collections need to be brought in to pay the obligations to the investors. And, sometimes things can break down. There can be issues. And there's always throughout the history of the market since, the 1970s, 1980s, through market cycles, there are events that demonstrate that, there's always going to be gaps, and just having legal documents are not, going to be the ultimate guardrails in ensuring the, good performance of deals. That's why, active market participants, innovative products and focuses like Voss are critical to ensure the integrity of structures and the performance separate above and beyond, some contract that folks entered into at closing.
Jesse, I always find myself discussing loan tapes and data tapes with some clients, just as you mentioned, going to their business itself. What are 2 stories that you remember, or I don't know, a couple of examples when you have to go beyond that lawyer role and, get into the trenches with your clients? Can you tell us, I don't know, maybe a fun example or a horror story, whatever comes to mind?
Right. Well, I guess the lesson learned from law, and this, is that you're only brought in after there's an issue often. oftentimes. So, the best lawyers are partners, throughout. But, I've had situations where, a structured finance deal was running along, and over the years from closing, performance by the parties drifted away from the obligations reflected in the contract. So, just by way of example, I was working with a lender and the borrower had sort of monthly deliverables or quarterly, annual in the way of loan tapes, officer certificates, sort of CPs. And it seemed like every quarter, every year that the deal developed, those deliverables kind of lessened. And, through the lapse in time and, employee turnover at the lender, the oversight and the deficiencies they let slide. And it was the sort of thing where, hey, if you would have been caught up initially, you could have avoided some issues down the road. And then we had to encounter, hey, deemed waiver of issues, deemed waiver of defaults, presented some real issues that closer diligence throughout would have really avoided. Well,
Honestly, I think Vale would be so happy to work with you, Jesse, because I just love that you mentioned two things that I think are really innovative, and most lawyers don't see the power in it, and it's the playbooks and the deal summary, actually giving your client, a map of how do you run this thing after you close it can be a definitely game changer. There's something that it's in the back of our minds all the time here at Vaas, and it's the UCC. You mentioned that part of the things that you give to them is playbooks and reminders so they can comply with everything they have done. One of those things is the UCC filings for secure transactions. It would be amazing if you can teach us a little bit about it. And what challenges does it have? Does it have any gaps? What do we need to understand to get into the US and play accordingly and comply with things?
Juanpa, and I will add, like, how did the UCC even start? Do you have like history on like how in the world did it become the UCC?
yeah, this is the really fun part of the conversation. I mean, look, the structured finance world is built on, as the name reflects, structure. And structure, I think, implies security, right? I mean, back to our initial overview examples, we're building something greater and beyond lender-borrower relationship into something where, there's security. And for there to be security, you have to define, okay, so why are we secured? What does that mean? What is our security for the obligations created, the, money capital provided? It gets down to there's collateral, there's comfort for payment obligations. The only way that you have the benefit of that is if you're meeting sort of legal paradigms that are going to afford you the benefit of that, right? So the threshold issue is, hey, defining collateral, defining the interested party's interest in that collateral, and then protecting that interest against competing interests. So to create that legal framework, the common law over I guess like in the British common law, then the US common law, developed case law that said, okay, if you do this, kind of security mechanism when you create your arrangement, then the parties will have, particular rights and interests in the collateral. If you do Y and Z, then you'll be perfected. You'll have perfection. You'll have protection against competing interests. That got really messy as deals got more complicated. There was different types of collateral. If your collateral for a loan is a piece of real estate, like a house, the law develops in one direction. But then what if it's like a bank account and there's money on it? Or what if it's a car? So in response to really the complexity and the patchwork, statutory paradigms develop. So states in the US passed laws to create like a commercial code that governed many aspects of commercial transactions. But one of the articles of that code, which came to be known as Article 9, really focused on the aspects of attachment of security interests in various goods and the perfection of security and all of that. And that's why we have now, as complicated and involved as the UCC is, it's at least it's a statute, it's a law that we can all look to and govern, as opposed to sort of a morass of case law. So the UCC is the law that governs collateral and folks' rights under secured transactions.
Yeah, thanks for that overview. Do you think where are the gaps in the UCC then today? Do you have like any examples of stories where the UCC was supposed to be, what people were using to, perfect the security and then also like check it for due diligence and monitoring, and maybe that wasn't enough?
Yeah. So when you close and then monitor a secure transaction, you want to ensure compliance with the UCC, because if you're not in compliance with the statute, then that's where issues present in your deal, in the collateral that's securing your deal. So, good lawyers, when they close the deal, will have a lot of focus on this deal involves collateral. Are the UCC elements met for that deal? So that will involve lien searches in all states, all jurisdictions, to see what filings on the collateral, on the entities owning the collateral might exist. And UCC filings are, one way where you perfect interest. So it's a matter of like due diligence at closing to ensure, you can reveal anything that the UCC had dictated, and then ensuring the perfection mechanics, the creation under the UCC in your collateral that you're getting the benefit of at closing through the mechanics afforded, and arranges by asset type, as as mentioned. And then that's a continuous process, upkeep of your interests as governed by the UCC, such as filing statements that are refreshed every 5 years in certain instances, ensuring possession of certain collateral like loan documents and certificates of title as may be required for other asset types, as all sort of diligence mechanics, review mechanics that you need to be very sensitive to and aware of given the UCC frameworks that are presented by law.
So, Jesse, would you say that there is currently no database that you can check for, or there's no US comprehensive database where you can look for all the affiliates related to one company? You're going to have to kind of be like a detective to figure out in each Secretary of State like filing, and therefore the way that you sort of get protected is because there's reps and warranty, or because there's like or because they're disclosing it in terms of like putting their own name within the legal document. Do you see that as an opportunity for the UCCs between all the different states, or between all the different states of the secretaries of state, to start having like what is this name called, like interoperability within them, or like the US government to sort of like abstract away the information from the different states? Like, how do you see that happening in the next couple of years? Because I think like if the UCC is here to stay and there's the new articles coming in, what if, the whole point is, how do you get as much information possible to reduce the possibility of fraud, right? So do you see that changing anytime soon, or do you think like there's all going to be very separate and there's not going to be interoperability within the states?
Yeah, it's a great question. There are it would make our lives a lot easier for sure if there was, some sort of coordinated global filing system. But, the reality is the US, contract law, of which the US UCC is part, is state specific. And each state has developed its own processes and systems. And there's very limited public interconnectivity between those. So there's certainly private technology overlays, like there are available systems where you can put in a search and it will purport to go into all the or the states that you select. But as far as government cooperation and technological advancement at their level, that has not happened to my knowledge in ways that would impact the deals that I work on. And frankly, I don't see it happening anytime in the very near future, although there's always conversations that crop up to varying degrees of realness from time to time. But I wish it would make our lives a lot easier, and maybe one day we'll actually get the some sort of cooperation, some sort of overlay when it comes to searching for collateral. Because to your point, Val, that would go a long way towards guarding against fraud and achieving the diligence that these deals really deserve.
It makes sense. I want to talk about the other two different properties that you mentioned that I think are very important: refreshments and possession. Let's start with refreshments. I think you mentioned a horror story related to refreshments. Do you want to share more of that? How did it happen, and what were like the big learnings there?
The UCC is kind of like a strict liability framework. If you're missing a technicality, it can jeopardize the rights and interests of the party that thinks they have the right and interest in something. So for a category of property, a UCC financing statement is filed in an applicable state's office that says, Juan Pablo has the first interest in a given property, and then the property is described. If any subsequent interest holder says, oh, I have a right in this property, then it is subordinate as a result of the senior filing. And so one of the technicalities, though, is that filing lapses in many cases after a 5-year period. And, the senior interested party doesn't get like a notification from the state or anything. Like they need to affirmatively go and file what's called a continuation statement that is filed in relation to the original financing statement and serves to continue to protect the interest. So there have been cases, and there was one very prominent case. I think I have some articles on my website that talk about it in more detail, but basically what happened was nobody filed a continuation statement in relation to a massive debt facility. There was a subsequent bankruptcy. There was a scramble by creditors on who had rights and assets. There was competing interests. And the failure to file a financing statement created real losses. Just one more technicality in the way of horror stories, Val, is folks need to think about authorizing leases of security interests, and the language that is filed is very important. And so there was it's called the UCC3, a termination statement in a filing. And there was this very large, billion-dollar deal where, some junior analysts or junior associates working together filed a termination statement that would have been appropriate, but the language was overly broad. And so magically, interests that shouldn't have been released were released, again, creating, real issues. So these aren't paper pushing technicalities. Like these are UCC, again, strict adherence, strict focus, ongoing monitoring, are critical to make sure the integrity of folks' interests created under law and contract are and continue to be secured.
Honestly, it gives me nightmares thinking about that situation, Jesse. I wouldn't want to be in the shoes of that junior associate. Damn, I can't believe they die, like the registries, they have a term. That's crazy. I mean, I understand it in a way that you can protect, credit and the industry, but it certainly gives you a lot of tasks and a lot of burden being a lender, right? You have to be really responsible and for sure be advised with a really diligent lawyer that knows when those financing statements registry are done. I don't know, Vale, but this sounds to me like a nightmare scenario. It's really great for borrowers, I guess, but for a lawyer, you have to be really on your toes all the time.
And Wampa, how do you kind of view it as different, the process in, say, Colombia or Mexico?
Mexico, so yes, its emerging markets are quite interesting in a way that they have been regulated around being competitive for foreign investments and protecting their internal markets. And I would say that the way emerging markets, specifically Colombia and Mexico, have been formed, these registries, is through fraud. So every time there's a huge scandal that, makes a lot of people lose money and puts into jeopardy the financial market, then the regulators create, as I told you, the centralized registry for digital notes in which everyone that has a digital note has to have it there and endorsements have to be there. Same happens for factoring and endorsements of invoices. So they have a centralized registry of invoices, and if you don't have the endorsement there of that invoice, it literally does not exist in your name. So they perfect the security interest in those centralized platforms, which gives you protection, but also, sometimes when the infrastructure is not great enough, then you're going to have to deal with, lagging web pages or maybe centralized databases that don't work as they should. That's how emerging markets usually work. But what's most interesting to me, Jesse, is Vaas even certain roles that have been created due to foreign investors coming into emerging markets. For example, you were mentioning that in the case where a borrower was, lagging in its obligations and due to company changes, people lost the knowledge of how to manage the transaction and the deal. When foreign investors come to emerging markets, they know that it's a possibility and they see everything with much more risk. So they start bringing to the table these extra players, the verification agents, the master servicers, the backup servicers, in case the originator or the primary servicers don't know how to do their job. So I was wondering, what's your take on that? Because these roles exist in our markets because foreign investors need them to bring their money here. How does it work in the States? Do you have something alike, backup servicers, verification agents? Does it exist? Do people use them?
Yeah, that's interesting to hear how that's developing in developed markets. I mean, to answer your question, yeah, so all those words exist. All those roles that you mentioned exist in different market practice depending on the asset type and the participants, but it's really all over the place, I'll say. I guess the way you've described it to me and Tom and V have described it to me in other calls is there's really the development of kind of like more of a blanket standard. In the US, it's a real patchwork. And it could really be deal specific. Uh, you know, but similar to, I guess, what you were saying, Juan Pablo, how in reaction to maybe like a big issue, a certain practice developed, like it's very reactive here too. So in the wake of, for example, the Great Recession and the mortgage crisis, you saw more, right, like master servicers, um, being a backstop to primary servicers, many of who failed. So there's the master servicer in that sense. But it really could depend on the transaction on, hey, what is the master servicer actually doing? In ABS, they'll often term something a backup servicer, but that could really range. And it's often a point of negotiation to some servicer saying, I'll serve as the backup. And, they're termed a cold backup servicer, but they're not really integrated in the month to month on a transaction, all the way to the spectrum of a hot backup servicer who's really integrated into the primary servicer's systems, for example. And they're verifying data and they're really positioned to step in on a moment's notice to keep a deal running. Verification of data of elements. There's verification agents. So it's developing, I'd say, very reactively, asset class specific, and I think the market's struggling to find kind of like industry standard and I think hopefully we'll get there, more so because frankly, closing deals now, often so much in the negotiation, so much of the cost are over those details. So that's standardization on verification, backup, and security elements to help achieve those pieces. I think is something that, our markets here in the US can, has some room for improvement and consistency, I'd say, for sure.
When you mentioned that it's asset class specific, which are the asset classes that you believe may profit the most from these roles? And I wanted to ask also, Jesse, how intense is the work that these backup servicers or verification agents do? Just to give you an example, we have deals in the emerging markets where we have to, review data tapes daily, release instructions from the trust daily, maybe twice a day. And all of those instructions have, the calculation of the performance covenants, the borrowing basis certificates, everything that you can imagine regarding guaranteeing the quality of the credits or of the collateral has to happen in a matter of hours. It's super intense and it's super connected to the originator's operations. How does it work there?
That's really interesting to hear. And I'm just curious, like, is it a belt and suspenders role you're playing? Like, is the originator or primary obligor doing it and then you're just checking the work, or you're the primary kind of doing all that work to approve a daily transaction?
We have both cases. So for example, in the master servicers, in the master's trust where you receive all the funds originated from the business of the originator, we have to check which credits belong to which lender. And then only us, we can send the instruction to send that to the SPVs of each lender, but we have to do it ourselves, not the originator, because they don't trust them.
So you're really providing a benefit of being like portfolio wide. Is that what you're saying? Like, so if a company has multiple, say, facilities, you're kind of having a bird's eye view. You're not serving for a transaction. Like, you're kind of making sure everything's okay across the portfolio.
We could just service one portfolio, but in LatAm specifically, you typically will have either one or multiple parties looking at the full 100% portfolio. So even if we're just looking at one portfolio and another master servicer is looking at another part of the portfolio, we both have 100% of the portfolio at all times. So we may need to make sure that we're sharing the data efficiently, which is something that in the US doesn't happen. As Wampa, there's two ways where we get if we're in the master trust, we either control, most of the time we control the cash flow. We're not actually the one sending the wire instruction, but sorry, we're sending the wire instruction, but it's the trustee that is moving the actual cash. And so when each payment comes in, let's say $1 payment came in, that dollar payment we need to tie to a specific loan to be tied to a specific SPV, and then we send the money. If you look at the US, the majority, at least to my knowledge, there is no master servicer concept in the equal terms as in LatAm, where you have a third party that is controlling the actual cash flows from the collections account directly. That is typically the originator that does it. The
Yeah, that's really
originator slash
interesting.
primary servicer. But
Right.
to us, that is one of the most important checks that the US has not even caught up to. Because like at the end of the day, you need to control cash, right? Like where the cash is coming from. And if you look at the majority of frauds, you could technically have at least more leverage to have prevented them had you been looking at the cash this whole time.
That's good insight. I think there's a lot of validity to that perspective, and that transactions in the US lean quite heavily. And, as is evident, sometimes, they're leaning too much on the integrity of the originators, servicers, where maybe a third party being heavily involved in cash flows in the way you're describing could be really beneficial to transactions. Now, of course, there is additional security that many transactions will build in. Through account control mechanics, through a trustee or loan agent having some degree of involvement. But frequently, those roles are a lot more segregated, defined by contract, often defined by a whole list of what those parties are not doing versus really taking ownership of validating things kind of in the way that you're describing. So yeah, definitely a contrast there, I'd say.
And I think that's one of the biggest interesting things that when a couple of the frauds currently exploded, a lot of people are asking, wait, who was supposed to do that, right? Like who was supposed to be checking for this not to happen? And people were calling to their own lawyers, to their own teams to figure it out. And everyone is like, oh, that's not my problem. Why? Because I never agreed to doing that. And the reason why they never agreed to that is because there's not industry standards in order to do it. And so when you're trying to fight those industry standards, you're fighting with like a lot of these comments like, well, if someone will commit fraud, they would actually do it. It creates too much pain for the operations. And there's all these things as to like why people don't want to change. And that actually leads me to another question, Jesse, which is like, when do you think the US market changes beyond just this master servicer role? Like there's a lot of things that the US needs to improve on. When do you think it actually becomes an industry standard for all these like things that should be happening?
There's a real benefit to operating in an emerging market, and that you don't have all the baggage of decades and decades of developing, oh, this is how we do deals. I mean, look, I work on deals where the document precedents have changed very little since literally the 1990s. Folks layering on provisions, they turn into these Frankenstein monsters of deal documents, deal structures, where it's like, can we just rip this whole thing up and start fresh? Everybody will be a lot better off. But you know how it is. The forces of inertia, the forces of, oh, this is how we've always done it, are really strong. So look, deals going south, bad things happening, unfortunately, are sometimes the only way that the needle really moves in a substantive way. So, that might need to be what it takes to have some real progress on some of the fronts that we've been discussing. I hope I'm wrong and that there's more appetite. And I know that there are discussions currently happening at some prominent market participants, particularly the capital providers, the big investment banks, et cetera. Standardizing, improving. We are seeing incremental safeguards put in place. So there is development. How quickly and how soon, I think remains to be seen, and will hinge on whether some of the cockroaches in the market, as Jamie Dimon said, have really finished scuttering past, or if there's more to come in the near future. I think will govern how quickly the market adopts to more safeguards and more modern processes. I don't know if that aligns with what you're seeing as you're having these conversations with U.S. and other markets, or if there's another perspective that you have on maybe the adoption or the appetite.
Definitely aligned with you, Jesse. I mean, I used to work at a firm too, and then when we saw the precedents of the credit agreements, because usually they were governed by New York law or the CTAs, when discussing these changes, it's a bit easier in emerging markets because, again, it's unknown for most lenders, so there's no standard. There might be a few precedents, but you have much more flexibility in changing clauses that work for the market. But yeah, I do believe
But that is
it
actually
can
That is very interesting. I had never thought of what you just said. And I think like we do have precedents a lot in LatAm, and those precedents are, hey, we learned of what should not be happening. Like if you look at the case of like the frauds currently in the US, we had those same frauds in Colombia, or we had them in Mexico.
20
But
years
everyone
ago.
was
Uh-huh.
learning. But people learned. And in the next set of docs, they changed it. Now the reason why they changed, because I think it's very interesting what you just said, is hey, because people they don't have as much experience in the regulation, they're much more open to changes. That is a very interesting. I had never thought of that. Can you expand more on that? Because like every time that I speak to someone, that it's every time that I like most of the time when I speak with someone and I explain what we do at Vaas, they immediately think blockchain, right? And I have to explain to them that it can be part of the future, but what we're truly trying to solve doesn't get solved with blockchain. Can you explain that further and to someone who's like immediately, oh, it's like, oh, what they're doing, it's blockchain. Like, where do you think the confusion comes from? And what can you tell them from the traditional Rails perspective that it hasn't met yet the blockchain world?
I mean, blockchain is just a tool, really, but a tool is only as good as the inputs. And then also you used a good word earlier, the interoperability with other systems or what have you. So, sourcing assets on a blockchain is a cool idea, for example. So evidencing a borrower-lender relationship on a blockchain is great. But then how does that translate to capital markets infrastructure, whether it's paying investors, verifying reporting off the blockchain, having traditional banks be involved has been a challenge. So yeah, for various segments of the capital markets infrastructure, blockchain has some cool use cases, but the challenge is stitching it all together. Look,
Can you give me an
it's only as good as the
example?
inputs. So yeah.
Can you give me an example to make this a little bit more lively, to make it a little bit more um, real? Like, can you give me an example where blockchain doesn't solve the problem today?
Yeah. So a loan can be evidenced by an obligation on a private blockchain, but the payments related to that loan still has to happen through a bank. So there could be a little bit of a disconnect there. The blockchain is not just, oh, we'll just put everything on the blockchain and the whole capital markets transaction is going to run on blockchain from origination through servicing through payment to investors. It just doesn't work in practice. And until, maybe some replacement architectures is built where all party, are comfortable with something running on blockchain rails. Perhaps something could be created along those lines. But I'm not a tech expert. I don't really know how that's going to look. And from the limited deals that have blockchain rails, it doesn't seem like the infrastructure is close to being there. But people have been talking about it again for over a decade. So maybe something will arise along those lines at some point.
I agree with you, Jesse. I believe this is one of the paradigms that, as a lawyer, one faces when doing structured finance, and is people are pushing and saying this new technology is going to change everything. Blockchain. Then it comes AI, and of course you can help it. But if you ask me, for me, it's more of how you adapt the characteristics of these new technologies to the already existing infrastructure and deals. Until that primary layer of infrastructure is not changed, then it's just going to make you more effective, maybe do cool things, as you say, but it's not going to change and it's not going to replace the structuring itself. It's
Absolutely.
hard. They constantly ask us, why don't you just do blockchain? And it's like, dude, asset-backed financing still doesn't work on blockchain. How do you do with mortgages? How do you do with assets that are, signed in ink and paper? It doesn't work.
Absolutely.
Jesse, thank you for coming on.
Yeah, no, this was fun. And I hope we can continue conversations.